David, you wrote your book on European design law 4 years ago, and you've now brought out a new edition.
I think the time's right. The area of law is comparatively new. We've only had it for just under 15 years. And there's been sufficient decisions, both at the Court of Justice level and also in member states in the last couple of years, to warrant a new edition.
Yeah. So what's the most interesting case, do you think?
I think at Court of Justice level, there's probably two that spring to mind. One is the referral from the Supreme Court of Ireland in a case about shirts, Karen Millen and Dunn's stores. And it's interesting for a couple of reasons. I think the questions referred from the Irish Supreme Court were in themselves quite obvious, but in giving the answer, the Court of Justice has given us quite a deal of useful information that we can use to interpret the regulation.
Yeah, and that was so it was mosaicing between different design features on different garments.
That's right. So in assessing what is the prior art and does it create the same overall impression on the informed user, you can't take various different pieces of prior art, so a collar from here, a cuff from somewhere else, and combine those into a mythical, non-disclosed article. Instead, you have to look at each piece of prior art and compare that with the design in question.
Yeah, it sounds like the Court of Justice got that one right.
I think that's right.
And there's something on burden of proof as well?
That's right. So in that particular case, we were dealing with unregistered community design rights, and the regulation provides that the holder of those rights has to prove certain things in order to get the presumption of validity. What Dunn's stores argued was not only did Karen Millen have to prove that the design was disclosed, but they also had to prove it was valid. And to do that, of course, if the Court of Justice had found that way, would have driven a coach and horses through the ability to protect unregistered rights in the Union.
Yeah, it gets the burden of proof the wrong way round, doesn't it?
That's right.
And the other big case is Gazebos, wasn't it?
Gazebos is a challenging case. It was a referral from the Bundesgerichtshof, the highest court in Germany, and that court asked 6 questions of the Court of Justice. The first few are to do with disclosure, and what we see there is the Court of Justice, again, giving broad protection to community design rights, because only obscure designs will not be included as part of the prior art.
Yeah, so there was something like a regional trade fair in China was
that's right, held to be something that could still come to the attention of the relevant circles. The other questions were to do with remedies, and there I think there were some issues around either the question that was asked, how it was translated, or how the Court of Justice then sort of worked with it, because I'm not sure those answers are clear, and I'm not particularly sure they're right.
Yeah. Well, we'll have to wait for another case to sort of work over that ground and maybe get it a bit better.
Quite possibly.
Just thinking, the Royal General Court gets it a bit in the neck. I know you comment that they've grappled with design law in less than spectacular fashion. So
I feel a little sorry for the General Court for a number of reasons. They don't have the benefit of an Advocate General. They are not specialists in design law. They don't actually hear many design law cases. There's only a few come through, unlike trademarks where they're now getting quite practiced at those decisions. And I think on occasion the parties themselves have not done a particularly good job of representing how the law should go. So a number of cases last year particularly were either right but for the wrong reasons or just wrong.
Yeah, and do we have things like the chocolate chip cookies?
I think that's a good example of a case that was just wrong, and it's a bit of a shame that the parties didn't take it further to the Court of Justice to get that
the inside of a cookie
sorted.
Isn't the design?
That's, I guess, the lesson we learned from it. The practical reality was that the registered design was for half a chocolate chip cookie with the sort of chocolate centre showing. And the General Court held that you couldn't look at half a cookie, even though that's what was registered.
Maybe them all in one.
You instead had to make it whole. I can think of perfectly valid reasons why you might want a registration for half a cookie, for example, to put on packaging to show consumers what's inside.
Yeah. But then there's umbrellas, and I think they got things better there, the General Court.
The umbrellas case is an exciting one because I see it as the General Court turning a bit away from some of its earlier case law on how the informed user goes about assessing whether two designs create the same overall impression. So an earlier case about lawnmowers or engines for lawnmowers, the General Court held that the informed user would stand behind the lawnmower, look over it and really only see or pay most attention to the top of the lawnmower. With an umbrella, obviously that creates difficulties because the informed user stands under the umbrella and is really only looking up at the top of it. And the General Court held that's not how to do it. We've had plenty of cases from the Court of Justice that says this is a detailed side-by-side comparison. So you need to look at all features of the design.
And users don't just use, they look at things as well.
Well, as the General Court said, the user of the umbrella will also see other people similarly using umbrellas, and so will also be looking at the outside of them.
Yeah. And so that's the Court of Justice, right sometimes, General Court, sometimes right. What other courts have we got?
Well, I think the member states actually are doing a tolerably good job of it, and we're now seeing good numbers of cases coming through, particularly in France, Germany, Spain, Italy, and the United Kingdom. I guess the larger member states where you might expect that, but also really interesting decisions coming out of a number of the Nordic countries, from Portugal, also from Poland. So
it must be quite difficult actually keeping track of these.
It is, and that's a good point you've picked up on. A number of countries don't actually publish their decisions, so they're hard to find. Others don't really index them in any way that's searchable. So I'm really reliant on the kindness of strangers to send decisions through when they find them.
Yeah, that's quite important to keep things up to date. The other thing I noticed, talking about sort of foreign decisions, is quite a lot of your footnotes are in foreign languages.
What I've tried to do is, where I've referred to a part of the regulation or the directive, is to give the language equivalent in French, German, Spanish and Italian. Those with English are the 5 official languages of OHIM, and the idea being to I guess, make people aware of the linguistic differences that are there, because sometimes they are actually quite important. An example perhaps comes from the Apple-Samsung litigation, where in the Spanish version of the regulation, a particular provision says that the court may stay the proceedings, whereas in all the other language versions bar one it says must stay. And obviously there's a difference between a mandatory requirement and a discretionary element, a discretionary decision for the judge.
Yeah, you mentioned Apple-Samsung, and there's a whole great big section on that as a case study in the book.
There is.
Really interesting.
At the time of the first edition, those particular proceedings had only got as far as the preliminary injunctions. So preliminary injunction had been issued in Germany and declined in the Netherlands. This edition of the book is able to update it right through to the end, so when the parties settled all European proceedings as between them. So it includes the final proceedings in the United Kingdom, including 4 trips to the Court of Appeal, as well as the proceedings in Spain, the Netherlands, up to the Supreme Court in the Netherlands, and in Germany, as well as the proceedings at OHIM. Unfortunately, no secret or privileged matter. It is all the information that's in there is taken directly from the judgments, the decisions of the various courts and tribunals, but all together in one place.
Yeah, I was going to say it's really nice to see it all in one place. And then, of course, your real bugbears, dotted lines.
Well, dotted lines, again, relevant in the Apple-Samsung case. And what we've seen across the European Union is different people interpreting dotted lines in different ways. And what that leads to is uncertainty. So, for example, in the Apple-Samsung proceedings, there were one type of dotted line, but in 2 places in Apple's design. And the courts interpreted those that represented a jack for earphones as meaning not claimed, which is sensible enough. But the dotted lines on the front of the design, they held that meant that it was a border beneath a transparent surface. Now, if dotted lines are going to mean different things within the same design, that's a difficulty for anyone coming to the register to know what it means and to be able to know what they can and can't do.
And actually that comes that you've got a picture in the book of the design as registered and then the design as interpreted by the English court, which frankly looked completely different. Because
a different case, that one involved shower units, and what I had was I had a draftsperson redraw the design to be what the judge had said that it meant, to show that it was very, very different to how the judge
and that's actually one of the features of your new edition. The first edition didn't have pictures. This one does. We can actually see what you're talking about.
I listened to the reviewers. Each of the reviews of the first edition said, can we please have pictures? And now we have some complexities with publishing pictures, because obviously the images in the judgments are often not a good enough quality to reproduce in a volume such as this. But I had them redrawn, and now the book has pictures.
Yeah, well, it's great fun. Thank you very much, David.
Rowan, thank you.